Let's talk about recent updates to Canada's Corruption of Foreign Public Officials Act and what this can mean for your organization. Recently, the Canadian government revoked its exception for facilitation payments under the Corruption of Foreign Public Officials Act, or CFPOA. This amendment demonstrates the government's continued efforts to ensure that Canadian businesses and organizations operating outside the country conduct themselves responsibly and with integrity in the global marketplace. Canada's anti-bribery law prohibits anyone from giving or offering a loan or reward, an advantage or benefit of any kind, either directly or through intermediaries, to a foreign public official in order to obtain or retain a business advantage. Facilitation payments, sometimes referred to as grease payments, are typically made to help expedite government services of a routine nature. That's part of a foreign public official's normal duties or their functions. These payments are now illegal and are no longer considered as a possible defense for bribery. The CFPOA sets out a list of examples of facilitation payments that are no longer excluded from the bribery offense. These include the following examples. Any payments for the issuance of permits, licenses, or other documents in order to qualify a person to do business. The processing of official documents such as visas and/or work permits. The provision of services such as telecommunication services or power and water supply. And payments for normal government services such as police protection or customs inspection related to the transportation of goods. These types of payments may now lead to criminal prosecution in Canada. This amendment now brings Canadian legislation into alignment with legislation of other countries, including the UK's Bribery Act. It also adopts recommendations from the OECD and other organizations like Transparency International for countries to take steps to discourage businesses from making any facilitation payments at all. While a facilitation payments exclusion is still found in the US Foreign Corrupt Practices Act, in practice it has had a very narrow interpretation accorded to it by the US enforcement agencies. And for this reason, most companies in the US do not provide for this exclusion in their anti-bribery compliance programs or their policies. Foreign bribery under Canadian law has broad jurisdictional reach and is punishable by up to 14 years in jail for individuals and has unlimited fines for businesses. It's also worthwhile to note that bribery and facilitation payments are not permitted regardless of whether the payment occurred in Canada or abroad. Accordingly, Canadian businesses operating in Canada and internationally would be wise to ensure that their current business practices and compliance programs reflect this latest development in anti-corruption enforcement in Canada. In addition to possible imprisonment and fines, convicted corporations could face being barred from doing business with the government for up to 10 years under Canada's integrity regime, as well as facing sanctions under equivalent debarment policies in other jurisdictions. The elimination of facilitation payments from the Anti-Corruption Act is an important reminder to Canadian corporations who operate internationally that adopting effective anti-bribery compliance, due diligence, and monitoring programs is critical to safeguarding their businesses from the severe risks of an anti-corruption violation. If nothing else, these recent changes present a good opportunity to check if your organization is taking the appropriate steps to manage its ongoing bribery risks.